Hi, everyone. I want to thank you all for your registry. Today, I'd like to share the use of internet evidence in Chinese patent practice. My presentation will be divided into 3 parts. First, I will begin with the legal basis and considerations for using internet evidence as prior art. Next, I will show you some examples to discuss different kinds of internet evidence. In the last, I will make a summary. Okay, let's move on. With more and more information exchanged and commercial activities conducted on the internet, a substantial amount of evidence and information related to existing technology or design can be found online. Here's some data. According to Weibo's latest statistics, about 15% of the citations by European examiners come from non-patent literature. In some fields, the proportion of non-patent literature is higher than patent literature. For example, in biochemistry, the European Patent Office found that more than 60% of examiners' citations were derived from non-patent literature. With the development of the internet, existing technologies in non-patent literature have new sources, such as web page, blogs, and other emerging publications, the so-called internet evidence. In China, the legal basis for using internet evidence as prior art is shown here. Item 5, Article 22 of the Chinese patent law reads, the existing technology or design refers to the technology or design known to the public domestically or abroad before the filing date. Guidelines further clarifies that the disclosure of existing technology includes publications, use, and other means. Publications in the context of the patent law means existing independent disseminating carriers of technical or designing content, which shall indicate or be supported by other evidence for the date of publication. Publications in accordance with the definition just mentioned can be printed or typed paper documents, audio or video materials. They can also be materials in other forms, such as those on the internet or in other online databases. Foreign patent offices also have similar regulations, so it has become common to use internet evidence as prior art. It is worth studying the principles and the rules of the use of internet evidence in patent prosecution. When determining whether internet evidence can be used as prior art, it could be considered from 3 aspects. They are authenticity, publicity, and publication time. Authenticity involves content and time. Usually, various factors such as the attributes and the qualifications of the platform, the interest relationship with the parties, and the formation and the collection of the evidence can be clues on the authenticity. Generally, government websites, well-known websites, and other online platforms with high reputation can be deemed to have the authenticity of public content and time, because the release time can only be changed by the platform and the source of the evidence is relatively reliable, unless we can prove there's an interest relationship with the platform and the parties, or its public content and the publication time, such as the upload time, release time, have been changed. For publicity and publication time, The publication time of internet evidence in accordance with the patent law should be the release time of the evidence. That is the starting time when the public can view the published content of the evidence. However, if the evidence is only available to specific people, it does not constitute disclosure in patent law. This is often the main issue when internet evidence, especially new media network evidence such as Weibo and WeChat, is used as evidence for prior art. The internet evidence involved in patent prosecution may include online libraries, social networks, e-commerce websites, video websites, etc. Next, we will discuss different kinds of internet evidence with some examples. For online libraries, the main issue is to determine the publication time. Usually, documents in the online library is shown with an upload date. In the early patent prosecution, most examiners use this upload date as the publication date of the document. However, depending on rules of the platform, the upload date does not necessarily constitute a publication date in patent law. Here's an example. In a decision of the request for invalidation regarding Baidu library, the panel indicates that there are two ways of uploading documents to Baidu library: ordinary documents and private documents. Ordinary documents are public to everyone, while private documents are only available to individuals. When the document is uploaded for the first time, you can select and set its publishing mode. These two modes can be switched at any time, and the upload time of the document remains unchanged. So if the user uploads a private document, the document is not made public to everyone on the date of upload. And the upload time is not the time when the document was made public. Even if the uploader changes the document from private to ordinary, the upload time will not change. So without other evidence, at the time of upload date, it is difficult to determine what kind the document belongs to, whether it is in a public state, and when it is known to the public. Without additional evidence, the time when the document was uploaded to the online library cannot be regarded as the publication time of the document. Social network evidence mainly includes documents and pictures from social media, such as blogs and WeChat. For social network evidence, the main issue is the publicity and publication date of the published content. We should carefully figure out whether the content remains public from the publication date, and to whom the content is public. The first example is about Weibo. Weibo can be understood as a microblog or one-sentence blog. Generally, individuals can log in by completing account registration and setting passwords on the platform. They can publish and change dynamic content. The content is stored on the server. For contents published on Weibo, the authenticity, publicity, and publication time should be considered comprehensively when determining whether these contents can be used as prior art. Here's an example about Sina Weibo. In a decision of the request for invalidation shown here, the prior art evidence submitted by the petitioner is 5 drawings released by the patentee under his Weibo account. The petitioner challenged the novelty of the patent based on these accompanying drawings. The petitioner believed that The public scope of each Weibo posting on Sina Weibo includes public to everyone, public to circle of friends, and public to myself. The public scope of Weibo can be modified only once. Public can be converted to private, but private cannot be converted to public. Based on this rule, the panel acknowledged the publication time of the relevant drawings. In addition, the search function of Weibo allows the public to search content and the user through keywords. For example, in this case, the Weibo post containing the drawings can be found by searching the name of the patentee. Second, everyone can see the content of Weibo through a third-party account without permission of the Weibo publisher. And the function of follow on Sina Weibo is a one-way relationship that does not require confirmation from the other party, and anyone can follow it. That is to say, the content published on Sina Weibo in this case is in a public state that the public can access it well. The internet evidence involved in this case is available to unspecified groups of people, and therefore constitutes a disclosure in patent law and can be used as prior art. Next, let's talk about WeChat. WeChat is a kind of chat platform and social media. WeChat provides many ways to publish information, including moments and the public platform. Generally, for an article published via WeChat public platform, the account owner cannot perform operations other than deleting the article. So without evidence to the contrary, the authenticity of the relevant evidence from the WeChat public platform can be determined. In a decision of the request for invalidation shown here, the evidence submitted by the petitioner involved the promotional materials of the patentee published on the WeChat public platform. The patentee and the petitioner disputed about whether the content of the WeChat public platform can be used as a legal and an effective source of prior art evidence, the publication time of the article, whether there's any change in the content after it is published, and whether the publication time uniquely corresponds to the published content. The panel held that, as far as the use of WeChat public platform is concerned, the account administrator is responsible for information release after obtaining the WeChat public account. But the release time is automatically generated by the system. Once an article is published on the platform, the account administrator can only delete it and does not have other modification rights. Subscribers of the official account and the general public do not have any modification rights either. So without evidence to the contrary, it should be considered that the content of the article published on the WeChat public platform in the evidence is directly related to the publication time. After the content in the evidence is published on the platform, subscribers who follow the official account can browse the content. At the same time, details can be searched and browsed with the use of search function. So the evidence can be obtained by unspecified groups and thus constitutes disclosure in patent law. From this example, we can learn the way that the panel analyzed the authenticity, publicity, and the publication time, and finally determine that the content published by the WeChat public platform can be used as evidence of prior art. It is also specifically mentioned that the search function can be used to access the WeChat official account and the content posted on the official account. We believe that the search function has played an important role in the accessibility of the content published on the WeChat public platform. Attention should be given to this function when judging the publicity of such kind of evidence. On the other hand, the public can follow the official account and browse its published content without permission from the platform or the official account. That is, the relevant content can be learned by unspecified groups of people. Therefore, the content published on this platform involved in this case constitutes disclosure in patent law and can be used as prior art. Weibo, WeChat official accounts are all open to unspecified public. The public can browse the content published in the account at any time by following the target account without authentication. So the information released by such self-media platforms can be used as prior art. However, whether the information published by WeChat Moments falls into the category of public domain is still controversial. In a decision of the request for invalidation shown here, the patent at issue is a design patent. The photo in the evidence submitted by the petitioner shows the moment's information of a WeChat user. The moments released the drawings earlier than the filing date of the patent at issue. The panel held that information released by moments does not constitute disclosure in patent law. The reason is, first, in regard to its role, Moments is a platform for users to share and follow their lives. It is not a place for users to directly conduct public online marketing activities. The scope of publishment is limited to WeChat friends. Only after the two parties have authenticated and become friends when they see each other and information posted by the other party. And there is a limit on the number of WeChat friends. From the attributes of moments and the limit of the number of friends, it can be concluded that Moments is essentially a private social platform limited to specific groups of people for communication. Regardless of the content that a WeChat user publishes in Moments, it cannot be separated from the attributes of Moments itself. The advertising information of products published in Moments can only be known to friends, not to the public in the context of patent law. Second, in regard to the setting of the permission in Moments, WeChat users can further choose to share information with all contacts, selected contacts, or just himself. User can change the way of sharing the information in Moments at any time, and there's no trace of such change. It is difficult to confirm the publishing status of the content in Moments. In subsequent judgments, publicity about Moments was further discussed. Zhejiang Higher People's Court challenged the decision by the panel. The court held that with the development of the use and the purpose of Moments, more and more people regard it as an important way for product marketing activities. Some WeChat Moments already have marketing functions. For the information publisher, he also hopes that the product information published in Moments will be accessible to more people, and he is unlikely to reject the request to add as a friend. Information published in Moments has the possibility of unlimited dissemination. The court held that it is unreasonable to deny the publicity of Moments only based on its attributes and the permission settings. However, contrary to Zhejiang Higher People's Court, Beijing Intellectual Property Court took the position that the existing design should be in a state where the relevant design is available to the public. Such state must exist in reality, not just as a possibility. If the parties claim that the relevant design is in a state that the public can learn it at will, they must provide evidence to prove that this state exists. In this case, none of the evidence can prove that the WeChat user did not set up friend verification, allowing anyone to add him as a friend and browse his moment. The involved product information is only part of the content in his moments, and other information about personal life may also be contained in his moments. So we cannot assume that he allows anyone to add him. The evidence in this case is not sufficient to prove that the information in the WeChat moments is in a state that the public can learn it at will. And we can see the Beijing Intellectual Property Court is cautious in determining the publicity of the evidence. In summary, whether the content of WeChat moments can be used as existing design is a controversial issue. The issue is focusing on the publicity and the publication time of the content. In our view, anyone who wants to view the moments needs to be a friend of the publisher, which may require verification by the publisher. So the content in moments is disseminated in a specific way unless we have other evidence to prove that the content has been disseminated to unspecified public. Second, because the permissions of WeChat moments can be modified without leaving a trace, the publicity and publication time of the content in moments cannot be confirmed. Third, WeChat friends can only be added through limited ways, such as friend recommendation, WeChat ID, and a mobile phone number. For the public, it is impossible to find a WeChat account through keyword search like Weibo or WeChat public platforms. For non-WeChat friends moments, there's no way to perform a search. The content of WeChat moments is not accessible to any WeChat users. For these reasons, it is difficult to use contents in WeChat moments as a priority at present. Other types of internet evidence may include e-commerce website and a video website. For e-commerce website, the time of user review can be used to determine the publication time of the item. Take Jingdong as an example. The possibility of tampering with the content on the web page by itself or others is very low. Jingdong sets certain rules for the formation, storage, deletion, and the modification of user reviews. Jingdong itself, merchants, or users cannot delete or modify user reviews. In certain relevant cases on appeal, the panel believes that when a purchase review of the product is earlier than the application date, it can be determined that the publication date of the product is earlier than the application date. For video websites, the publicity of the video is difficult to prove. Take Youku as an example. In certain relevant case on appeal, the panel found that permission of Youku video can be set and changed at any time without any trace on the server. So it cannot be directly determined that the video on Youku is available to the public before the application date. For this reason, the video on Youku does not constitute disclosure in patent law. Okay, we have discussed some examples for different kinds of internet evidence. You can see the use of internet evidence should be analyzed carefully and case by case. Let's make a summary. For authenticity, we can analyze based on attributes and qualifications of the disclosure platform, the interest relationship with the relevant parties, and the formation and collection of the evidence. For publicity and publication time, it's complicated. Oftentimes, we determine whether the evidence is public to a certain group of people, how does the publication status last, and whether the status can be changed. However, with the development of technology and update of the platform, whether certain types of internet evidence can be regarded as prior art still need to be treated in development view. For example, maybe in the future, the change of permission for the video on the video website can be traced. At that time, some of the video may be eligible for being used as a prior art. If you need advice or support, or if you would like further details for updates, feel free to contact us and we will be happy to help. This is my presentation today. I just want to say thank you so much for your time. I really appreciate it.
Thanks for your sharing, Mr. Zhou. And hello, everyone. Good morning, good afternoon, and good evening. Thanks for attending this webinar. My name is Xin Zhang. I'm partner of SPTL, and I'm also today's moderator. I'm in charge of patent matters in IT-related technical field. As one of the leading IP firms in China, we provide a full range of services for IP matters, both domestically and abroad. Today, one of our senior attorneys, Mr. Chen Zhou, had already shared some of information and his opinions about the use of internet evidence in Chinese patent practice. Let me briefly introduce Mr. Zhou. Mr. Zhou has joined SPTL for more than 10 years. He has a wealth of experience in the field of computer science and microelectronics. His practice involves patent prosecution, patent search and analysis, patent invalidation proceeding, and patent infringement litigation. Thank you again for your quite informative and helpful sharing, Mr. Zhou. Now, let's go to the Q&A session. I see a question from, I guess this is a lady, Mrs. Linda P. Falcon. Thank you, Mr. Zhou, for your informative presentation. You've discussed the publication time of online libraries. Regarding the publicity, how about the purchase function? Would it be an obstacle for the publicity of the article on the library? Would you please share some of your opinions about this, Mr. Chen Zhou?
Okay, thank you, Linda, for your question. I guess you are talking about the paid access function of online library. Well, as far as I know, the paid access function only will not prevent the article from being a prior art, because this function does not affect the confidentiality of the article as long as anyone can pay for it. Also, some online libraries may require account registration before browsing the content. Such rule will not be an obstacle as long as anyone can register an account. Yeah, I think so.
Thank you for your explanation. The next question from Christina Jacobs, which goes like this. Mr. Zhou, thank you for your introduction. As you may know, sometimes the online evidence may be deleted intentionally. My question is what we can do to preserve the evidence when we find it. Please.
Okay. It's a big question. Thank you, Christina, for your question. When retaining evidence, we should try our best to preserve the whole evidence. In addition to saving the complete URL information, it is strongly recommended to save the complete page by saving electronic documents or web page screenshots, including the URL, the content, the publication time, etc. Sometimes we may find other evidence can be used to prove the publication time. We should also save information that shows the relevance of this evidence.
Okay.
So much.
Okay, thank you. Thank you for your answering. And thank you all. I think it's already enough for Q&A session. And it's almost the time to conclude today's webinar. Different jurisdictions may have different criteria on use of internet evidence. We hope that today's introduction could be of your help when facing issues with internet evidence in Chinese patent practice. As always, we, SPTL, will provide webinars centered on various topics in IP in order for it to bring you the most added value. Please follow our post or notification. This is all for today's webinar. Thank you all, and hope to see you next time.
Thank you.
Thank you. Bye-bye.
Bye-bye.